All right, let's get started. Tonight is part 10 in our series about the first chapter of Sanhedrin. I apologize that last week's source packet said part 14 at the top because apparently I didn't proofread it well enough, and I apologize. But last week was part 9. This week is part 10. We are going to spend most of this evening on page 6a in Sanhedrin, but although we will start on page 5b. If you are listening to this at some point in the future and would like a copy of the packet, please email me at deborahklapper@gmail.com. All right, I'm going to share my screen though so everybody can see it in real time right now in the Zoom. Okay, so we had been discussing the nature of permission, which is to say a license to judge cases. And one of the cases that we talked about last week was Rav, who was given permission when he went to Babylonia. He was given permission to judge all cases except the permitting of firstborns, because it was thought that he was too good at ruminant biology, and he might permit some animals on the basis of permanent damage to their bodies. Other people would say that the damage looked temporary, and then people would get the impression that temporary damage was enough to permit a firstborn. Okay, so we are going to begin by referring back to that, and we're going to spend a little bit of time on finishing up the issue of permission to judge, and then we are going to go back to something else we mentioned a few weeks ago and talk about that. Okay, so the Gemara begins, Pshita lepalga. It's obvious that it works partially. That is to say that you can give permission to somebody to judge, but only in some cases. Hak amar demahani, because we just said that it works for Rav. Al tanai mai, but what about if we give somebody permission to judge temporarily or conditionally? Does that work? Tashma. So here's a story. Da'amar le Rabbi Yochanan le Rav Shemen. So Rabbi Yochanan said to Rav Shemen. Rav Shemen, by the way, seems to be the same person as Rabbi Shimon bar Abba, although he is always called Rav Shemen when he's with Rabbi Yochanan. So maybe it's a nickname. Maybe it's not actually the same person. I don't know. I have no expertise in this matter. In any case, Rabbi Yochanan said to Rav Shemen, he said, you have permission to judge from us until you come back. So I don't know where Rav Shemen is going or how long he's going to be there, but apparently this permission only lasts until he returns. So it seems like, yes, in fact, you can have permission which is not permanent, not unconditional. Okay, moving right along. So we had mentioned, I think we've now mentioned it several times, a position of Shmuel that we're now going to quote again, and we're going to, a couple of times this evening, we're going to have this word gufa. Gufa means, we mentioned this before tangentially in the middle of a different conversation, but we didn't really give it the attention it deserves, so we're quoting it again so we can talk about it for real. And this is our first gufa of the evening. Gufa Amar Shmuel. Shmuel said, Shnayim shedanu dinehem din. Two who judge, their judgment is judgment, meaning like it's binding, you have to do what they said. Ela shenikra beit din chatzuf, but they're called a chutz bedek beit din, right? That's it. It's not an appropriate thing for them to be doing. They shouldn't do that, but it works. Yativ Rav Nachman v'ka'amar lahashmata. So Rav Nachman is sitting there reciting this statement that Shmuel said. Remember that at this point, it would seem that a lot of the Torah learning of what we call Gemara is still being done orally. And there's a certain amount of just, repeating things over and over again that goes into memorizing. And also there seems to be therefore a certain amount of overhearing people saying stuff and saying, no, you must have gotten that wrong, and then having an argument about it. In any case, so Rav Nachman is reciting the statement of Shmuel, and Eitive Rava Rav Nachman. Rava challenged Rav Nachman, and he said, this Mishnah that we have later in Sanhedrin seems to prove that you've got Shmuel wrong, because Shmuel can't have said that. He said, Afilu shnayim mizakin, o shnayim mechayevin, ve'achad omer eini yodea, yosifu hadayan. So this is in the third chapter of Sanhedrin, which deals with dysfunctional courts in a number of different ways. And one of the cases that they deal with is if you have a case where you've got 3 judges and they come to the end of the discussion and they vote, and 2 of them vote innocent, and one of them says, actually, I can't make up my mind. Or 2 of them vote guilty, and the third one says, well, actually, I can't make up my mind. But either way, the person who can't make up his mind does not count as a judge here. And so we don't have an adequate quorum, and so we have to add more judges. And it seems like if that's the case, well, the Gemara says, V'i ita, if it was true, I mean, if what Shmuel said was true, then lahavu kashnayim shadanu. Then these 2 people who can make up their minds on the court should be just like a court of 2 that judged to begin with, and we should just let them vote for innocence or conviction, whatever it is they voted for. Ignore the guy who says he can't make up his mind and move on. And the fact that we don't do that seems to demonstrate that Shmuel has to be wrong. Remembering that Shmuel is an Amora, and as an Amora, it's his job to interpret the Mishnah and the other material from the same time period as the Mishnah. He's not allowed to disagree with it, unless there's another Tana that disagrees, in which case he can take sides, which we'll see that's going to get a little bit more complicated than I just said in a few minutes. Okay. So for this, we're just going to say Shani Hatam, but that's different. The case in the Mishnah in the 3rd chapter about the guy who can't make up, the judge who can't make up his mind, that case did mi ikara adata dislata yati, because when they originally sat down to judge, when they originally constituted themselves as a court, they were a court of 3, and so it might just be that if you sit down with the intent to be a court of 3. You need at least a quorum of the people that you started out with in order to finish the case. And that might not have anything at all to do with the question of whether you could start out with 2 from the beginning. Because the case that Shmuel is talking about is a case where they never had 3 to start with, so maybe it would be okay. All right, now we try another challenge. Eitive. Rabban Shimon ben Gamliel hadin bishlosha upshara bishnayim. So in this braita, Rabban Shimon ben Gamliel says that regular court judgment is done with 3, and pshara, which we're calling compromise here, is done with 2. I didn't want to translate it either as arbitration or as mediation because it has some aspects of each of those American systems and some unique features. But it's a system in which it seems to be, and we'll see it get fleshed out a little more this evening, a system in which the litigants can agree to be judged by 1 or more people who are not qualified to judge. They could be, for example, the relatives of one of the people involved. They could be uneducated. They could be women who are, well, there's a dispute about whether women are normally qualified to judge or not, but even according to people who think that they're not, they can do arbitration. And they don't, in a pshara, you don't have to, in fact, the point is kind of not to decide the case in accordance with the law. The point is to come up with something in the middle that makes everybody sort of equally unhappy so that you can, go on with life without actually deciding what the facts or the law was. Okay, so we're going to call it compromise because it has, as I said, aspects of both mediation and arbitration in it. And Rabbi Shimon ben Gamliel says that you need 2 deciders, we'll call them, arbitrators, mediators, whatever they are, in order to do compromise. And he also says, V'yafeh koach pshara mikoach hadin. And, excuse me, compromise or pshara is a stronger form than regular judgment. Sheshnayim shedanu balei dinim yicholim lachzor behem. Because Rabban Shimon ben Gamliel says, if you have two judges who judge a regular case, then it's not binding. The litigants can withdraw. They can say, never mind, I'm going to a different court. Vishnayim sh'asu pshara, but if you have two who did pshara, a compromise, ein bali dinin yicholin lachzor behem. The litigants cannot back out. They're stuck. It's binding. So that sounds, and we'll get back to the issues with pshara more later, but for right now, we're going to focus on the question of how many people sit on a regular court. It sounds like Rabban Shimon ben Gamliel said that if two regular judges judge in a regular court, their judgment is not binding, which seems to be diametrically opposed to what Shmuel said, because he said if two judges judge in a regular court, their judgment is a judgment, which seems to be the same thing as their judgment is binding. V'chitema, so you might say, pligi Rabbanan alei de Rabban Shimon ben Gamliel. You might say that there are other rabbis who disagree with Rabban Shimon ben Gamliel. He's one guy, we have his name. Presumably, if the text gives his name, that means that he's arguing with somebody. And then Shmuel could hold with whoever the other mystery party is. The problem with that is v'ha'amar Rabbi Abahu shnayim shedanu l'divrei hakol ein dinehem. Rabbi Abahu says that if two judge, then everybody agrees that their judgment is not a judgment. Which, if Rabbi Abahu were a Tana, that would be the end, and Shmuel would simply lose. But Rabbi Abahu is an Amora. Note that even though Rabbi Abahu has the title Rabbi, Reish Bet Yud, rather than the title Rav, he is still an Amora. The title Rabbi continued to be used in the land of Israel for some time after the close of the Mishnah. So while anybody with the title Rav is automatically an Amora, people with the title Rabbi can be either one, and you have to actually know who the person is. Okay, so the Gemara says, Gavra a Gavra karamit? Are you telling me that one person disagrees with another person? To which it's a rhetorical question. The answer is, of course, people disagree with each other. And while Rabbi Abahu is totally entitled to look at the statement of Rabban Shimon ben Gamliel and say, that looks to me like a statement that everybody agrees that two who judge, it's not binding. Shmuel is equally entitled to look at the statement of Rabban Shimon ben Gamliel and say, well, if it quotes Rabban Shimon ben Gamliel by name, that sounds like he's disagreeing with somebody. I will hold like whoever it is he's disagreeing with. So that effectively ends that conversation, and Shmuel is entitled to hold like the mystery party that apparently Shmuel believes holds that if two judges judge, then the judgment is binding. Okay, but we now have another gufa. So we're going to go back and talk more about this statement of Rabbi Abahu about everybody agreeing that two judges who judge, their judgment is binding, because we have a challenge to that too. So, Eitive Rabbi Abba Rabbi Abahu. Rabbi Abba challenged Rabbi Abahu with the following mission. Danet Hadin, if a judge, it seems an individual judge, judging by himself, judged a case, Vizikat Chayav, and he declared innocent somebody who was guilty, or Vichievet Hazakai, or he declared guilty somebody who is innocent, V'timeet tahor, or he declared as tameh something that was tahor, or v'tiheret tameh, or he declared tahor something that's tameh. Masha asa asui u'mishalemi beto. Whatever he did is done, and it's binding, and you're stuck with it. But there's going to be financial damage from any of these from any of these kinds of decisions. And he's going to have to pay out of his own pocket to reimburse the person who lost money because he decided wrong.
But Deborah, how do they know if somebody's judging? They don't know what. How do they know that the guy that Rabbi Abba, that the single judge judged, is really guilty? If he judged him innocent, then he's innocent.
That's a really good question. It might be that more evidence comes to light afterwards. It might just be that his judgment gets overturned by a properly constituted court of 3 judges. But it's not entirely clear what the case is here.
Uh-huh. Did that happen actually? That similar to our system now, that things went to a higher court and original judgments got overturned?
Not ordinarily, but if you had a case where the judgment was not binding, right, and you can convince another court that the person who judged the original case had no right to judge it to begin with, then presumably you can sue from scratch, and it won't be that if you can convince your court that the case has not yet been judged, then they'll judge it from scratch. It's going to turn out here that this individual judge actually, it's not his problem. Wasn't the facts. His problem was that he ruled in accordance with a legal position that it turns out that the rest of the rabbinic community thinks is not followed. So there, it really does sound like you've got his colleagues intervening somehow.
Right. Okay.
Exactly what that looks like practically or politically, I am not sure.
Right. Right. Okay. Thanks.
Sure. Okay. So that should be a challenge to Rabbi Abahu, because it seems to indicate that you have one person judging and it says what he did was done, right? It sounds like you don't have a choice but to follow his instructions, and that you can sue the judge for taking your stuff and giving it to someone else and make him pay you back. But in the meantime, you have to do what he says. And that's what Rabbi Abahu said. Everyone agrees that that the judgment of 2 isn't binding. It seems likely that if the judgment of 1 person were binding, the judgment of 2 people would also be binding. So it seems like this is a challenge to Rabbi Abahu. But we are going to decide that we're talking about a specific case. Okay, so what are we talking about? De kibluhu alai. We're talking about a case where this individual person who is judging the case was accepted by the litigants, meaning they agreed to do in advance whatever it is that he said. And in that case, it really shouldn't make any difference what he told them to do. They should have to do it. So, which is what the Gemara says. In that case, why does he have to pay? And the answer to that is the Amrule Dayantalan Din Torah. They said, please, we want you to judge this case in accordance with the law. So now they said, we'll do whatever you say, but we want the case decided in accordance with this particular set of rules. He didn't follow the rules. So they agreed to do what he said. So they have to do what he said, but he didn't follow the rules. So he's liable. Amalei Rav Safra Rabbi Abba. So Rav Safra said to Rabbi Abba, well, okay, but like, what's the case here? What kind of error did this fellow make? If we say that he was wrong about a matter of Mishnah, which seems to mean that he simply did not know a Mishnah, or he misquoted one, right? So he literally got the rules wrong, which it would be gross incompetence from our perspective here. So if that's what we're saying happened here, then v'ha'amar Rav Sheshet amar Rabbi Ami ta'abed dvar Mishnah chozer. But the problem with that is that Rav Sheshet said that Rabbi Ami said that if you had a judge who made a mistake in a matter of Mishnah, then that just gets that's just not binding. It gets reversed. You can't enforce a judgment decision that was based on that kind of extreme error in knowledge of the law. Ella de ta'ab shikul hadat. So it must be that he made a mistake in a shikul hadat, in a judgment call. So the Gemara very reasonably says, well, what's that? What does it mean to make a mistake in a judgment? Amar of Papa, kegon tre tanai v'tre amorai de pli hadat. So you have a case, according to Rav Papa, where you had a dispute between two Tanas, and then that dispute gets carried over, it continues, and it continues to be a dispute between two Amoras. Velo itmar hilchata lo kamar velo kamar. And we don't have a statement that the law is like this side or that the law is like the other side. But v'sugyan ta'alma aliba dechad minay. But the conversation, the discussion about the law is always conducted according to the assumptions of one side of the dispute. And so if you were paying enough attention, you would have noticed that all of the conversations we have in the Beit Midrash only make sense if we rule like Rabbi X. But that's a level of analysis that apparently this judge was not capable of or didn't engage in, and he didn't notice. And ve'azal ihu ve'avad kidach, and he went and he ruled according to the other judge. Right, so there's nothing explicit in the tradition saying that the law doesn't go like this side. But if you were really paying attention and you were really analyzing all of the discussions people were having and really thinking it through, you would have noticed that everyone seems to assume that this is the way the law goes. This is not gross incompetence, but it's like a little bit incompetence. Okay, in that case, that's hainu shikul hadat. That's a judgment call. And if the judge makes that kind of error, it's not reversible, right? People still have to follow his instructions because what he did was plausible, just wrong. And so in this case with the individual single judge who had been asked to arbitrate a case based on the law, and he got the law almost right, like it could have gone like that, but in the end it didn't go like that, then that his ruling is enforceable, but we still make him pay the losing party. So now that was the end of our second tangent, and now we're going to go back to our conversation about Shmuel. Remember, Shmuel says that two judges who judge, it works, but they're a Beit Din Chatzuf, they're a chutzpahdik Beit Din, as opposed to Rabbi Abahu, who believes that everyone agrees that two judges who judge that their ruling isn't binding. So we're going to suggest that their dispute is parallel to a dispute between Tanas. And this is a little bit self-referential because we just a second ago talked in general about the idea of having a dispute between two Tanaim, which is then carried over as a dispute between two Amoraim. It will turn out that we don't actually think that's what happened here, but the Gemara spends a lot of time trying to line up disputes and see whether it's the same dispute going on over a long period of time or whether they're independent. Okay, so Lemaka tonight. Let's say that this dispute is like this dispute between two Tanaim. Bitsua bishlosha. Bitsua, according to Rashi, is the same thing as pshara, and I have translated it here as compromise, same as I translated pshara. Bitsua bishlosha. Bitsua is done by 3. Compromise is done by 3. Divrei Rabbi Meir, according to Rabbi Meir. V'chachamim omrim pshara b'yachid. But the rabbis say that you only need one judge to preside over a compromise. And you may notice that this text here is not about judgment. right? Shmuel and Rabbi Abahu were having their dispute about regular, normal court cases in which judges decide according to the law and their judgment is binding because it's law. And we seem to have sort of taken a side road here into the world of pshara or bitsua, in which we don't really decide according to the law, and the judgment is binding because you agreed in advance you do whatever this person said or these people said. And the Gemara points this out. Savru el chulei alma makshinan pshara l'din. So it seems that according to whoever suggested that these disputes are parallel, it would seem that they think that the one thing everyone does agree on is that you need the same number of judges to do a compromise that you do to do a regular judgment. And so then we're suggesting that, well, Rabbi Meir thinks you need 3 judges for a compromise. Presumably, he also thinks you need 3 judges for a judgment. And the Chachamim think that you only need 1 judge for a compromise. Perhaps they also think you only need 1 judge for a judgment. And yes, I know that 1 is not the same thing as 2. We're going to reject this anyway, so we're not quite going to get to that level of granularity. Okay. So, but we start out thinking that they must be assuming that pshara and din require the same number of judges. My love, but wait a minute, aren't they actually disagreeing about this? Demar savar din bishlosha, umar savar din bishnayim. One of them thinks that judgment is with 3, and one thinks the judgment is with 2. And they think that pshara and din work the same way. No, we're going to reject that. Dekule alma din bishlosha. Both Rabbi Meir and the Chachamim of this Braita think that the regular court case is judged by 3. And in fact, pshara and din are not necessarily the same. And in fact, this is what they're disagreeing about. Demar savar makshinan pshara l'din. That one of them thinks that, in fact, pshara, compromise, is parallel to judgment. Umar savar lo makshinam pshara l'din. And the other one thinks that compromise is not parallel to judgment. Right? So in fact, everyone agrees that a regular court case is with 3. And then the question is whether, in order to do a compromise, whether you need the same number of judges as for a regular court case or not. So that's not going to have anything to do with our case, with our dispute. So we reject that parallel. Now, the Gemara notes, though, that we so far have, with reference to pshara, compromise, we now have 3 possibly distinct positions. We had, so lema tzlata tanai b'pshara. Let's say that there are 3 tanas with distinct positions about compromise. Demar savar bishlosha, one of them said 3, that would be Rabbi Meir. And Umar savar bishnayim, and one of them, that would be Rabban Shimon ben Gamliel, said with 2. Umar savar biyachid, and one of them thought with only 1, with a single judge. That would be the rabbis who disagreed with Rabbi Meir. So maybe we actually have a 3-way dispute. So we've now abandoned the question of how many judges you need for a regular judgment and gone off on yet another tangent about the question of how many judges you need for a compromise. So Amar of Acha Breda Rav Ika, Rav Acha, son of Rav Ika, says, if Eitema Rav Yemar bar Shalmia, or maybe really it was Rav Yemar bar Shalmia, somehow the tradition about who said this got corrupted. Mand Amar Trey Afilu Chadnami. He's the position that says 2, that's Rabban Shimon ben Gamliel, would also be okay with one judge in a case of compromise. Remember, Rabban Shimon ben Gamliel didn't say that you specifically need 2. What he said was that a compromise that's brokered by 2 is binding, while a compromise that's while a judgment that's judged by 2 is not binding. So maybe he chose the example of 2 there to say what he wanted to say about the regular judgment, and it was just sort of the comment about 2 arbitrators was sort of incidental. And he doesn't really care whether you have two or one. Or in fact, maybe he cares whether you have two or one, but not because he doesn't think it would work. And then in that case, the reason why Rabban Shimon ben Gamliel would say that you should have two is not that it wouldn't work otherwise, but so that there would be witnesses. Right? In general, the definition of witnesses in halacha is that you have to have two. One witness is useful for a very limited set of circumstances, but for the most part, we don't really consider something testimony unless we have two kosher witnesses who together testify to identical facts. And so if you are someday going to need to prove that this compromise took place and what the decision was, so Rabban Shimon ben Gamliel might reasonably say that he wants two uninterested parties present who can just, tell people what the judgment was. And for that, he would want two, even though the actual making of the compromise would be binding even with only one, even if he doesn't think that's a very good idea. Okay, so now Rav Ashi says, Amar Rav Ashi, Shma mina pshara ena tzricha kinyan. Rav Ashi says, I can conclude from this statement that pshara does not require a kinyan. Now, a kinyan is a formal act of acquisition. That's not a very helpful definition, but in terms of acquiring things, what it does is it allows you to pick up or handle or pull on or something like that, a movable object in order to acquire an immovable object. Right? The normal way to acquire movable property is by picking it up, or if it's an animal, by pulling on its leash or calling to it or something like that, making it move because you said so. If I want to buy a house or a field, right, so you can't pick those things up. So there's a symbolic replacement in which you pick up something else. Okay, that then gets imported. That's called making a kinyan, which I suppose literally means making a purchase. That gets imported into the acceptance of responsibilities and the acceptance of obligations. And so that you can also say, by picking up this object, I am making myself responsible to whatever, to pay money, to do whatever the judge says, whatever. And that makes it's a physical act in the physical world that shows your level of commitment. And it makes, generally speaking, it makes whatever it is that you did legally binding. So Rav Ashi is saying, if I required a kinyan for the creation of an arbitration panel, then I would not care how many people there are on the arbitration panel. If you picked up the handkerchief and said, I agree to do whatever this person says, it shouldn't make any difference how many people there are. It should be, whatever happens then should be binding regardless. So he says, from the fact that people care how many arbitrators there are, mediators, whatever you want to call them, from that fact, I can tell there must not be a kinyan. Because if it did require a kinyan, then according to somebody who thinks that it requires a kinyan, why would I need three judges? Tiski betray velikni mine. It should be enough to have two, and then if you want something that makes it binding, you don't need to have a pretend court panel. Instead, you could just have a kinyan. So he says, if people think that they need to have three people up there, that must mean that they think they need the authority of the court system to make it work. So that must mean that there is not a kinyan. But we reject this. Inference, and the halacha is the helchata pshara tzricha kinyan. The halacha, in fact, is that in order to create a panel for pshara, you do, in fact, I believe both litigants, in fact, have to do a kinyan as a commitment that they will follow through on whatever it is that they're told to do. This is the, I guess, a halachic equivalent of a binding arbitration agreement. It's legally binding and requires you then to do whatever they say they're going to do. Although being, right, from 1500 years ago or whatever this is, it is designed to be carried out by people who are not necessarily literate. Unlike a binding arbitration agreement where I think you probably need not just to be literate, but also to have an attorney. In any case, we have one more little bit before we get to the end of our page. Tanu Rabbanan, the Braita says, Keshem shedin bishlosha, kach bitzua bishlosha. So this Braita says, just as judgment is with three, likewise compromise is with three. It's not clear to me what this is adding because it's repeating a position that we already had. We don't seem to be planning to discuss it. It just seems to be here. And then we have another Braita fragment, which is going to get discussed in next week or the week after, but is not really connected directly to what we've been doing so far. Nigmar hadin iyata rashai liftzah, which says if once the case has been concluded, and exactly what it means for the case to be concluded might be a little bit iffy, but for right now, let's assume that means the judges have decided what they think the law is, what they think the decision is supposed to be, or possibly they've actually issued a ruling, not clear which. So once that happens, you are not allowed to compromise, which seems to mean the court's not allowed to encourage the litigants to compromise. Presumably, nothing stops the litigants themselves from simply not fighting with each other anymore. That, but I guess we'll see next week if that's if I'm right about that. We are going to spend next week on the whether bitsua or pshara, whatever you want to call it, whether compromise is a good thing or a bad thing, and this is going to be connected to that. I want to remind you about a couple of things that we saw in tonight's share. One of them, which I pointed out at the time, is this idea of a gufa. The word gufa is gimel vav pei aleph, and I suppose literally it means itself, the thing itself. But the role that it plays in the Gemara is that it says, I quoted this thing before, tangentially. Now I'm going to quote it again in order to discuss it directly. Now I'm going to take this thing that we mentioned in passing, and I'm going to make it the direct topic of our conversation briefly. And we saw that happened on the one hand with the statement of Shmuel about the two-judge panel, and it created a new topic for the overall conversation. We also saw it as a minor part of a tangent about Rabbi Abahu creating a tangent on a tangent, or maybe a tangent on a tangent on a tangent, I don't remember anymore. And just, as a parenthetical in the middle of something. It can work either way. And the other thing I wanted to point out is when we were discussing what a shikul hadat is, what a judgment call is, we mentioned that sometimes that shikul hadat can only exist in a place where the text doesn't, the tradition, because they didn't have a written text, doesn't specify that the halacha is one way or the other. And here we have in front of us, in fact, a specification that the halacha follows a particular position. And in fact, it seems to follow a position which is contrary to all of the named positions that we had in our Gemara, right? That the halacha is that the pshara does require a kinyan. Presumably there were a lot of people who held this position. We just don't have any of their names. We also saw, I think last spring in the last chapter of Pesachim, I think we saw a couple of cases where the Gemara said the halacha followed a particular position and then changed its mind. And that in fact, the halacha didn't follow that position. So it's not always as easy as the Gemara made it sound to figure out which way the halacha goes based on the Gemara, even as we have it now, relatively edited and in relatively limited quantity. How you could have figured it out in real time while people were still having these fights out loud, I suspect that would have required real judgment calls in a way that it doesn't anymore. Okay, so that's what I have for this evening. Are there questions?
Yes. How did we get to the whole idea of a kinyan when we're not necessarily judging a case of acquiring an object? I thought we were talking about money, and it just seemed like there was this shift in the Gemara all of a sudden, and I didn't get how that shift was made.
Good. So this kinyan does not seem to be an acquisition of an object at all. The object is there only symbolically. This kinyan is the acceptance of a responsibility. If you've been at the chatan's tish at a wedding, and the
Thursday.
What?
This Thursday. Thank you. Yeah.
The Mesader Kiddushin will hand an object to the Chatan and say, here, pick this up.
Oh, right.
Mesader Kiddushin say, lift this over your head.
Right.
People have different standards for exactly what the kinyan looks like. And what the Chatan is doing is he's not buying anything. In fact, what he's doing is accepting all of the responsibilities that are listed in the ketubah, which include financial things like financially supporting the kala, but it also includes like sort of vague social things like I will honor you, right? Like that's definitely not a financially enforceable obligation on the face of it, although I'm sure we have a financial definition somewhere. But the kinyan is a recognition that you have to do something. I think this is a kinyan much more similar to that, where you pick up the handkerchief or the ballpoint pen or the whatever it is,
right.
And in the process you accept that whatever this person you've put in charge says, you're going to have to do whatever they say.
So
it might not involve transferring money.
So do we do that always in halacha whenever one person is accepting responsibility for another? We do a kinyan?
We do it a lot. Many rabbis do a kinyan when they accept responsibility to sell your chametz for you.
Right.
Right. Certainly, Rabbi Chesses, I think, prefers to. I feel like Rabbi Sender insisted on it, but I
think he did, from what I remember. Yeah.
And it's a way of marking that something happened when the thing that happened would otherwise be sort of difficult to put your finger on.
Right. Although a ketubah is actual proof that you're responsible for something, whereas when I tell the rabbi to sell my chametz, it's just this verb. Oh no, we do fill out a form.
I mean, there is a document there also, although I think the document is a lot
less binding.
Well, what I was going to say, I think the purpose of the document is so that the rabbi knows where your chametz is and where your house key is, more than it's not his actual instructions. Whereas the ketubah is mostly a record of the fact that the kinyan took place. The kinyan is the real thing. The ketubah is a record of the fact that the Eidim saw the kinyan.
Oh, I thought it was the opposite. Like the ketubah is your proof. Here it is. You don't need anything else.
Well, the truth is that if the chatan lets the witnesses sign the ketubah, then it would be binding whether or not he did the kinyan because he, agreed to owe the money. But the language of the ketubah is we, the witnesses, saw this kinyan take place. That's what it's
Okay. Okay, thank you. That clarifies it.
Sure. Okay. As far as I know, we'll see you guys next Monday night, and we will talk about whether compromise is a good thing or not. So we can all look forward to that.
Well, as a parent, you're not supposed to say that. Compromise is always supposed to be good.
Well, compromise is always supposed to be good when I decide what the compromise. If I'm the one compromising, that's a different story.
Of course. Oh, well, we'll see next week where it goes.
Indeed. Okay. Good night, everybody. See you next week.
Thanks so much.
Thank you. Bye.
Bye.
Bye-bye.